Welcome to this deep dive into the legal architecture of Indian identity. In this series, we map the foundational principles of Indian citizenship, from the constitutional roots laid down in Articles 5 through 11, to the statutory framework of the Citizenship Act of 1955, and the contemporary mechanics of the 2019 amendment. By understanding these pillars, we can clearly see how India defines who belongs, how that status is acquired, and how it is protected or modified in our evolving democracy. To understand India's identity, we must first recognize its structure, a single, unified national citizenship. Unlike some federal systems that operate under a dual citizenship model, where individuals hold concurrent citizenship of both their state and the country, India follows a different path. Under the Indian framework, individuals are residents of their respective states, but they are citizens solely of the Republic. This design ensures a singular national identity that transcends regional boundaries. When the Indian Constitution commenced on January 26, 1950, it needed a baseline to define who exactly was an Indian citizen. This task was addressed in Part 2 of the Constitution, specifically through Articles 5 through 11. These articles provided the initial criteria for citizenship at the moment of the Republic's birth. While these articles established the starting point, they also built a future bridge, acknowledging that the definition of a citizen would need to evolve through subsequent parliamentary law. Article 5 established the primary baseline of belonging for citizenship at the commencement of the Constitution. To qualify, an individual had to meet two main criteria. First, they had to be domiciled in India. Additionally, they had to fulfill at least one of three conditions: having been born in India, having had either parent born in India, or having been ordinarily resident in India for the 5 years immediately preceding January 26, 1950. Meeting the domicile requirement plus any one of these three conditions automatically granted citizenship. The Constitution also had to address the massive human displacement caused by the partition. Article 6 dealt with migrants moving from Pakistan to India. Article 7 addressed the more complex scenario of individuals who had migrated to Pakistan after March 1, 1947, but then returned to India legally for permanent resettlement, providing them a path to claim citizenship. Articles 8, 9, and 10 established the rules for global Indians and the continuity of rights. Article 8 grants citizenship rights to persons of Indian origin residing outside India, provided they or their parents or grandparents were born in undivided India. Article 9 deals with the loss of citizenship, stating that the voluntary acquisition of foreign citizenship results in the automatic termination of Indian citizenship. Finally, Article 10 guarantees the continuance of existing citizenship rights, though these are always subject to the laws passed by Parliament. While the Constitution set the initial baseline for citizenship in 1950, it also included Article 11, which acts as a bridge to the future. This vital article granted Parliament the ultimate power to regulate, acquire, and terminate citizenship through subsequent law. It ensured that citizenship would not remain static, but could be adapted by the legislature to meet the needs of the nation. Exercising the power granted by Article 11, the Parliament enacted the Citizenship Act of 1955. This comprehensive statutory framework governs all citizenship matters after 1950. The Act acts as the legal rulebook, dictating precisely how national identity is legally gained through 5 specific paths, and how it can be taken away through 3 distinct paths. Under the 1955 Act, there are 5 distinct legal paths to acquire Indian citizenship. First, by birth; second, by descent; third, by registration; fourth, by naturalization; and fifth, by incorporation of territory. These 5 pillars form the comprehensive framework for how an individual can become a legal citizen of India. Just as there are ways to join, there are 3 legal paths through which Indian citizenship can be lost. First is renunciation, which is the voluntary surrender of Indian citizenship by an individual. Second is termination, an automatic loss of citizenship triggered immediately upon a citizen acquiring the passport of another country. Third is deprivation, which involves the forced removal of citizenship by the government, such as in cases involving fraud, disloyalty to the Constitution, or trading with an enemy. The Citizenship Act of 1955 is not a static text. It is a living document that has been amended several times to adapt to the changing needs of the nation. Over the decades, from 1986 through 2015, various amendments were introduced to refine the rules of citizenship. However, the 2019 amendment, known as the Citizenship Amendment Act or CAA, represents the most significant modern structural shift in this legislative framework. The Citizenship Amendment Act of 2019 introduced a specific pathway to citizenship by naturalization through a three-filter process. First, the who filter. It applies to 6 specific religious minority groups: Hindus, Sikhs, Jains, Christians, Parsis, and Buddhists, who faced religious persecution or fear of persecution in their countries of origin. Second, the from where filter. These individuals must have migrated from 3 specific neighboring countries: Afghanistan, Pakistan, or Bangladesh. Finally, the modification filter. For these specific groups who entered India on or before December 31, 2014. The residency requirement for naturalization is reduced to 5 years. This creates an accelerated path compared to the standard requirements. It is important to note that the provisions of the CAA 2019 do not apply uniformly across the entire country. Certain regions are specifically exempted to protect their unique cultural and social fabric. Zone Type A includes tribal areas in Assam, Meghalaya, Mizoram, and Tripura that fall under the 6th schedule of the Constitution. Zone Type B covers areas governed by the Inner Line system under the Bengal Eastern Frontier Regulation, 1873, which regulates travel into these protected regions. To summarize, we have mapped the complete architectural framework of Indian citizenship. It begins with the bedrock of the Constitution, specifically Articles 5 through 11, which set the foundation. Article 11 serves as the crucial bridge, granting Parliament the ongoing authority to regulate citizenship. This power manifests in the Citizenship Act of 1955, which defines the legal channels for acquiring or losing one's status. Finally, modern updates, most notably the CAA 2019, have introduced specific regional exemptions and naturalization rules, ensuring the architecture remains dynamic and responsive to our times. As we conclude our deep dive into the architecture of Indian citizenship, 3 foundational pillars stand clear. First, unity by design. The single citizenship framework structurally unites a diverse nation under one identity. Second, parliamentary authority. Article 11 ensures that Parliament holds the ultimate, ongoing power to regulate national identity. Third, continuous adaptation. From the partition migrations of 1947 to the CAA of 2019, statutory law continuously adapts to our country's historical and geopolitical realities. Thank you for joining us in exploring the framework that defines what it means to be a citizen of India. Don't forget to subscribe, like, share, comment if you enjoyed this quick revision.